time for general debate has expired. Pursuant to the rule, the bill shall be considered read for amendment under the 5-minute rule. No amendment to the bill is in order except those printed in House Report 110-422. Each amendment may be offered only in the order printed in the report by a member designated in the report, shall be considered read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent of the amendment, shall not be subject to amendment, and shall not be subject to a demand for division of the question. Amendment number 3 in the report may be withdrawn. It is now in order to consider amendment number 1 printed in House Report 110-422. For what purposes the gentleman from California rise? The clerk will designate the amendment.
Amendment number 1 printed in House Report number 110-422, offered by Mr. George Miller of California.
Pursuant to House Resolution 793, the gentleman from California, Mr. Miller, and a member opposed will each control 10 minutes. The gentleman from California is recognized.
Madam Speaker, I yield myself 4 minutes.
The gentleman is recognized for 4 minutes.
Madam Speaker, I rise in support of an amendment to this ENDA legislation that I and Mr. Stupak have written to ensure that this law will protect religious liberties of religious corporations, societies, associations, and in particular, religious schools, including those religious schools that are not affiliated with any particular church or denomination. Our amendment would make it clear that the ENDA exemption matches the religious exemption found in Title VII of the Civil Rights Act of 1964. Under my amendment, the religious corporation, association, or school would be categorically exempt from ENDA. In addition to our amendment, it also clarifies that the references to the term married refer to the federal definition of marriage as between one man and one woman as enacted in 1996, federal law referred to as the Defense of Marriage Act. With respect to the religious exemption, this issue has been a cause of a lot of confusion in past weeks. The religious exemption that was part of the ENDA bill that was passed out of the Education Labor Committee on October 18th was exceptionally broad. However, several non-denominational religious schools nevertheless raised concerns that they might not be covered under the ENDA exemption. For example, the president of Wheaton College in Naperville, Illinois, sent a letter to Representative Tim Walberg in advance of the Education Labor Committee's markup on ENDA. Mr. Walberg shared that letter with the entire committee, and our Republican colleagues argued that Wheaton College, which is clearly a religious school, despite the fact that it is not controlled by any affiliation or with a specific church or covered by the ENDA, may not be covered by the ENDA exemption. That argument was incorrect. Wheaton, along with other religious schools and organizations such as the Council for Christian Colleges and Universities, asked that we ensure that the Act categorically exempt religious organizations as in Section 702A of Title VII, and we have done precisely what Wheaton College and the Council for Christian Colleges has asked us to do. Under this amendment, if a religious organization, including a religious school, is exempt under either 702A or arguably the broader section of 703E2, then the organization or school is exempt from ENDA, period. So if a school qualifies in either one of those exemptions under Title VII, it is categorically, as they requested, exempt from ENDA. By directly referencing Title VII, we also ensure that many decades of case law on Title VII religious exemption are imported to ENDA. This amendment provides clarity for religious schools that have experience with the Title VII exemption, and it should satisfy all of the legitimate concerns about ENDA. Let me be clear. The Title VII exemption, and therefore the ENDA exemption, applies to both non-denominational religious schools like Wheaton and church-affiliated schools. As one court explained, even though the Christian corporation or organization is non-denominational, it nevertheless may subscribe to a particular religious view on which other Christians do not agree, and conversely, it may disagree with the religious views of other Christians. And to go on to the court, this is precisely the situation which Title VII exemptions were enacted, and the exemptions allow religious institutions to employ only persons whose beliefs are consistent with the views of that religious organization. And that is the purpose of this exemption. That is the purpose of this amendment. In addition to clarifying the scope of the ENDA religious exemption, my amendment also specifically states that the reference to marriage in ENDA refers to the definition of marriage as defined in federal law. Specifically, these terms in ENDA are given the meaning provided by federal law that is referred to in the Defense of Marriage Act, which defines marriage for federal purposes as a union of one man and one woman. This is a definition that applies to ENDA, and my amendment makes it that definition absolutely clear. Madam Speaker, because of our amendment offers strong protection to religious organizations, including non-denominational, non-affiliated religious schools, I yield myself 30 additional seconds.
Gentleman is recognized.
Thank you. And because of our amendment clarifies the Defense of Marriage Act and operates to define the term marriage in this bill, I trust that the Miller Amendment will receive a large bipartisan vote in its favor, and I would like now to yield to my co-sponsor of this legislation, Mr. Stupak. I yield the gentleman 4 minutes.
For 4 minutes.
I thank the chairman of the committee. I rise in support of the Stupak-Miller Amendment to the Employment Non-Discrimination Act of 2007. This amendment makes two important clarifications. First, our amendment asserts and clarifies that any religious organization that is currently covered by the Civil Rights Act of 1964 would be exempt from the Employment Non-Discrimination Act. This will continue to protect religious organizations, including corporations, schools, associations, and societies from religious discrimination claims. For the past 40-plus years, religious high schools, colleges, and other organizations throughout the nation have been allowed to hire individuals based on that institution's religious principles. Today, as we adopt employment protections based on sexual orientation, these principles should be upheld. Continuing America's long-standing separation of church and state, this amendment will ensure that the federal government does not unconstitutionally infringe on religious organizations' hiring practices. Religious schools and organizations throughout my district and throughout this nation will continue to freely practice their beliefs without being afraid of being charged with discrimination. Several major religious organizations support the inclusion of the religious exemption in ENDA, including the U.S. Conference of Catholic Bishops, Union of Orthodox Jewish Congregations of America, and the General Conference of the Seventh-day Adventist Church. The Miller-Stupak Amendment also opposes the Defense of Marriage Act. It clarifies that any reference to marriage in ENDA refers to the legal union between one man and one woman as husband and wife. In 1996, a bipartisan group of 342 members, including myself, voted in favor of the Defense of Marriage Act. Marriage is between a man and woman. I support including a clear definition of marriage as a union between a man and woman in this legislation. No American should have to face discrimination in the workplace regardless of their race, gender, or sexual orientation. However, religious organizations should be able to hire individuals who agree with their religious beliefs. It is also important to make it explicitly clear that marriage is a union between a man and a woman, and that no part of the Employment Non-Discrimination Act could be misconstrued to undercut the Defense of Marriage Act. I urge my colleagues to join with me and the chairman in voting for this amendment. With the inclusion of this amendment, I encourage members to vote for final passage of the Employment Non-Discrimination Act. Madam Speaker, I ask for a yes vote on the Miller-Stupak Amendment, and I yield back the balance of my time, and I thank the gentleman for working with me on this amendment.
Gentleman reserves his time.
Thank you, gentlemen. I reserve the balance of my time.
Gentleman reserves his time. For what purpose does the gentleman from California rise?
I rise to claim the time in opposition to the amendment.
Gentleman is recognized for 10 minutes. Gentleman is recognized for 10 minutes.
Madam Speaker, I yield myself such time as I may consume. With this amendment, the majority tries to correct fundamental flaws related to hiring protections for faith-based institutions and the preservation of marriage. I will reluctantly support this relatively futile attempt, but let me be clear. On the issues of faith-based protections and the institution of marriage, this amendment fails to solve the problems. As such, even with adoption of this amendment, the underlying bill should be defeated. For months, my colleagues and I have raised substantive legal and policy concerns related to this legislation. After a series of legislative false starts, the bill brought to the floor continues to pose a number of challenges. The amendment offered by Chairman Miller is an obvious attempt to address a few, but certainly not all, of the issues we've identified. We expressed concern that the bill created a new anti-discrimination framework outside the existing scope of Title VII of the Civil Rights Act of 1964. Among other things, this allowed for a new set of provisions to dictate the hiring rights of religious organizations, thereby stripping faith-based institutions of their long-standing Title VII protections. I appreciate that the majority has recognized and agreed with our concerns about how this bill would intrude on religious freedom. In response to those concerns, the amendment moves closer to Title VII. Inexplicably, however, it still leaves out an important piece of current law. Chairman Miller says his amendment fully restores protections to faith-based institutions. It does not. We express concern that the bill could undermine the rights of states to define, protect, and preserve the institution of marriage. The Miller Amendment deletes troublesome provisions related to employee benefits for same-sex couples and references the Federal Defense of Marriage Act, which defines marriage as a union between one man and one woman. Unfortunately, despite these steps, or perhaps even because of them, the bill taken as a whole continues to create potential conflicts between state and federal marriage laws. Chairman Miller says his amendment protects the rights of states to define and preserve traditional marriage. It does not. A presidential veto threat has been issued on constitutional and policy grounds. This amendment fails to fully address those concerns. I reluctantly support passage of this amendment to partially address a few of the problems we've identified throughout this bill's troubled legislative path. But I remind my colleagues that this amendment is not enough. The bill remains a litigation trap that undermines marriage and provides insufficient protections to faith-based organizations. Even after supporting this amendment, I urge my colleagues to reject the underlying bill, and I reserve the balance of my time.
Reserves his time, and without objection, the time claimed in opposition will be managed by Mr. McKeon. The gentleman from California.
Let me just ask, does the gentleman have additional speakers? Do you have additional? We only have one speaker left. We have the right to close.
Gentleman
Right
from
to close? We know we do.
Gentleman from California has the right to close.
Who has the right to close?
Gentleman from California. Mr. No? The gentleman from California, Mr. McKeon, has the right to close.
Which gentleman from California?
Gentleman from California, Mr. McKeon, has the right to close.
Thank you. We're all from California.
California, I'll take the right to close.
I'll go ahead and yield.
I just have one speaker left.
Yeah, and we have another speaker and none close.
Okay.
I'm happy to yield at this time to the gentleman from Georgia, Representative Brown, 2 minutes.
Gentleman from Georgia is recognized for 2 minutes.
Thank the gentleman for yielding. Mr. Speaker, the House of Representatives is debating H.R. 3685, the Employment Non-Discrimination Act today. As well-meaning as this title of the bill sounds, I want the constituents in my 10th Congressional District of Georgia and all Americans to know why this legislation is bad for Georgia and bad for America. Just like the ill-conceived hate crimes legislation that this Democratic majority passed, this bill will increase discrimination, yes, increase, and not decrease it. I believe in the Constitution of the United States as our founding fathers intended. The First Amendment of our Constitution expressly protects religious freedom. So while I'm opposed to discrimination, I also am opposed to creating special rights and privileges for certain classes, and that is exactly what this bill does. This bill would elevate one person's desire for a particular job over another person's right to practice and honor their religious beliefs. If H.R. 3685 is signed into law, and I pray that it will not be, it would deny the civil rights of employers, and it would abridge the freedom of association enshrined in our First Amendment. ENDA will enforce employers, including Christians, Muslims, Jews, and peoples of other faiths, to hire individuals that are diametrically opposed to their fundamental belief system. If they stand up for their religious beliefs and refuse to hire those opposed to their faith, they will be sued. In fact, one thing the bill will accomplish is to dramatically increase lawsuits against employers. Further, while the Democratic majority will argue that religious organizations exempt, the highly nuanced definition contained in this bill for religious organizations and religious educational institutions is so bad as to make this exemption essentially meaningless. The bill would grant special employment privileges and protected minority status to anyone that defines themselves by their sexual orientation.
Yield the gentleman additional 30 seconds.
Gentleman is recognized for 30 seconds.
Further, an employer can be sued for not only making an employment decision based on a person's sexual orientation, but on his perception of their orientation. Countless individuals and organizations, including Christian and Jewish schools, Christian bookstores, and even religious daycare providers, will be forced to either hire a homosexual or transgender individual or face prosecution. This legislation is unnecessary and is unconstitutional. I urge my colleagues on both sides of the aisle to do the right and courageous thing and to vote no on H.R. 3685.
Gentleman's time has expired. The gentleman from California.
Might I inquire how much time we have left?
Gentleman from California, Mr. McKeon, has 4.5 minutes. The gentleman from California, Mr. Miller, has 3 minutes.
We have 2 more, so this time I'd be happy to yield to the gentleman from Indiana, Mr. Souder. You said 4.5 minutes?
Yes.
I yield him 3.5 of those minutes.
The gentleman from Indiana is recognized for 3.5 minutes.
Thank you, and I want to thank Chairman Miller as a former Republican staff director on the Children and Family Committee. When he was chairman of that and working with the committee, I found, as he said earlier, that he listened to the Hoekstra Amendment Committee and made some adjustments, that in fact, occasionally he's right. It's occasional, but occasionally he's right. This addressed some of our concerns. It did not address all of our concerns. That, as you know, when you're dealing with religious law or any law, it isn't at the heart of the matter, it's at the fringes. In communion, can minors take real alcohol? Americans smoke pipe. Here we're not dealing with, and this amendment helps clarify that, we're not dealing with religious colleges, we're not dealing with the church proper. But law in the United States, as we deal with religious discrimination, ability to deal whether sexual discrimination trumps religious discrimination, which is fundamentally what this bill is about, that people who hold deeply held religious beliefs, which is part of Orthodox Jewish teaching, fundamentalist Muslim teaching, and in the Bible, unlike civil rights, where civil rights were led by William Wilberforce in England, by the abolitionists of America, because the Bible was not explicit. But here, in fact, the Bible is explicit, the Quran is explicit, the Torah is explicit, and people have deep religious held beliefs. So 85% of the Christian bookstores in America would not be covered by this protection. That certain types of church camps would not be, depending on how it's handled. Group homes, they're often independent and do not have an overt religious message. They grew out of the faith message of a church, but do not necessarily now have an overtly religious mission. They're part of the outgrowth of the religion, would be covered. They wouldn't be able to have husband and wife be the house parents under this bill. That religious law is a lot more complex than it was presented today. One of the other challenges here is when we're trying to talk about how do we debate in public life over people of faith and which party they're going to be and how we're going to reach out to this. The American people have heard in this debate today, people who seriously are uncomfortable with this debate. We don't like to talk about this type of thing. I've tried to treat everybody in my life, regardless of how they've been in this Congress or friends at back home or people I've worked with respect and dignity, and do not practice personal discrimination. But I have heard my religion and my religious belief called prejudiced, bigoted, hate-filled, that the predominant religions in America have had their basic beliefs. Those who believe in a literal Bible have seen their faith smeared today on this House floor. And I am very disappointed in much of the tone. I understand the passion. I understand why people who have a homosexual lifestyle feel they've been discriminated against. But this is a classic question in our country. If, in fact, nobody could get a job, we'd be facing a different challenge today. I openly admit that. But the challenge here is, do people who have deeply held religious convictions based in their fundamental texts of their faith have the right to practice their faith too, or are they going to be trumped? This amendment is a step, but it's only a step. I yield back.
Gentleman yields back his time. The gentleman from California.
I yield the remaining time to the gentleman from New Jersey, Mr. Anders.
Gentleman from New Jersey is recognized for 3 minutes.
I ask unanimous consent to revise and extend my remarks.
Without objection.
Thank the chairman for yielding. I rise in support of this well-thought-out amendment from Chairman Miller and Mr. Stupak. I think it quite fairly addresses some of the concerns people have raised. First, with respect to religion, On October 4th, 2007, the president of Spring Arbor University wrote to our colleague, Mr. Wahlberg from Michigan, and Mr. President Lifton worried about the scope of the religious exemption in the underlying bill, and here's what he said. I urge you to remove the problematic religious definition language currently in ENDA and ensure that the Act categorically exempts religious organizations as in Section 702A of Title VII of the Civil Rights Act. Here's what the amendment in front of us says, Madam Chair. This act shall not apply to a corporation, association, educational institution, or society that is exempt from the religious discrimination provisions of Title VII of the Civil Rights Act of 1964 pursuant to Section 702A, precisely what was asked for. Second, I've heard concerns that there's preferential treatment or special rights for persons protected under this bill. The gentleman and others should read page 8 of the underlying bill, subparagraph F, which is captioned no preferential treatment or quotas. Let me read from it, Madam Chair. Nothing in this act shall be construed or interpreted to require or permit any covered entity to grant preferential treatment to any individual or any group because of the actual or perceived sexual orientation of such individual. It's helpful to read the bill. Finally, we've heard suggestions that somehow the institution of marriage is undermined. It's very important to read the second part of Mr. Miller and Mr. Stupak's amendment, subsection C, and I will read it. As used in this act, the term married or marry refer to marriage as such term is defined in Section 7 of Title I, which is the Defense of Marriage Act, which explicitly defines marriage as a union between one man and one woman. These were concerns that were raised. They are met. I respect and appreciate the fact that the ranking member of the full committee will vote yes on this amendment. So will I. And so will an overwhelming majority, so we can proceed to passage of this bill with a strong bipartisan majority. And I would yield back the balance of our time and urge a yes vote on this amendment.
Gentleman yields back his time. Gentleman from California.
Madam Speaker, I yield myself the balance of my
Gentleman is
time.
recognized for 1 minute.
Now, this is an emotional issue. It's a serious issue, and I think it's hard for some of us, I know, on this to control our passions. And it's disturbing that some are offended, have been offended during the debate today, and I feel badly about that. My concerns are more with the flaws that I see in the bill. I'm concerned that we're all trying to end discrimination. I don't think you do that by passing laws. I think we have to engage people with their hearts, in their minds, and try to work at that approach. While this amendment does not correct or even address all of the challenges created by the underlying legislation, I recognize the incremental steps it takes. I appreciate the chairman for making this effort at trying to resolve these issues. I will support its passage, and I yield back the balance of my time.
Gentleman yields back the balance of his time. The question is on the amendment offered by the gentleman from California. Those in favor say aye. Those opposed say no. In the opinion of the chair, the ayes have it. The amendment is adopted.